Thank you very much once again, MANYE, and greetings to each and everyone watching us, wherever you find yourself. Uh, what we'd like to put across this morning regarding our education on this today is in case you have a child and you are the parent, you've been living here for 7 years, residence, and the child is less than 18, we would like to let you know that there is an opportunity somewhere in order to make an application, both the child and the parent as well. First, let's start with the child. If a child is brought into this country, depending on the age, and the child is less than 18, finds himself spending the first 7 years in this country, and if it would be reasonable to expect them to leave the country, the law says no, you can make an application on that basis under paragraph 276 ADE of the immigration rules in order for the child to be regularized and get a leave to remain on a private life application. What this is all about is when we look at our immigration rules, they've made it in such a way that each and every one where you find yourself in can have at least something to take away home. Which I mean when I talk about something to take away home, in case you haven't got any leave to remain in this country, depending on your circumstance, we can digest and come out and say, you are in this category. So on that basis, you can make an application based on your circumstance to get your leave in this country. Let's look at the ages differences, whereby you are in between 18 and 24, you have an application, and whereby the 18 and 24, you spend half of your life in this country. You can make an application on the private life as well. If you are under 18 and you spend 7 continuous years in this country, you can also make an application on the basis of your private life. And this is what we're going to discuss in details. And also, if you are or you are the age from 25 and above, and you spend 20 good years in this country, you can also make an application on the basis of private life in UK under the immigration rules. So we are at the moment going to concentrate on the child who is less than 18. And what the requirement is, the child has to be under 18, and he or she has to live continuously in the UK for at least 7 years. And it will be reasonable to expect them to leave the country in case they say, no, leave this country. So as such, these are the basic requirements, the basic qualification that makes you as a child in order for you to apply on the basis of your private life. When we go further, this child issue has come as a result of case laws in such a way that the cases which has come forward and created all these laws let us know that is it reasonable or is it unreasonable for you to say that the child to leave this country, or if not, the child will stay and the parents rather leave this country. So what the law says is, in some way, if they are supposed to go by the law, there will be strict adherence to the law. By saying, no, we will allow the child to live here, the child who is 7 years, but the parent, we will tell you to go because you haven't got a leave in this country. But when we look at our human rights in the UK here, the parents are taking care of the child and they form a family life in such a way that you can't tell the parent to leave this country and the child will be alone. And who is going to take care of the child? So what the law allows us to derivate or use as part of the application is whereby the child has made an application on the basis that I've lived here 5 years. It entitles the parents as well, provided they are taking care of the child and they haven't got leave in UK, to also apply and be having a leave in this country. So the law comes out the definition of who is a qualifying child under the section 117D1 of the Nationality, Immigration and Asylum Act 2002, stating that a qualified child is a British citizen child or one who has lived in the UK for a continuous period of 7 years or more. So in this case, we are not looking at the British child who has a right to live here, but we're looking at the child who has lived here for 7 good years, be it not from other country and settled in UK on the basis with the parents, or on the other hand, the child wasn't born here. So in this case, what the law says or what the law talks about is, if such child is in such situation, they can make an application, that child can make an application on the basis of a private life by telling them that, look, I've come to UK. When I was here, I was just maybe less than 18 years. And I've lived here for 7 years. But when I came in here, I came with my parents, but my parents haven't got leave here. At the moment, I've spent my 7 years life here, and I would like to make an application on the basis of a private life. Provided you can come out with this scenario or this requirement, the law says you can make an application as a child on the basis of your private life under paragraph 276AD of the immigration rules. But what we are going to look at it is it reasonable for a child to have the leave here or not? So Home Office look at the circumstances, what is going to bring into the child's life if they say they're not going to allow the child or issue him the leave to remain. What they normally consider are the extent of wider family ties the child has formed in the UK here. Also, they look at it in such a way that has the child integrate into the UK culture and UK social ties and others. Also, they also look at it whether removal would have rise to significant risk to the child's health. So this information puts together for them, Home Office make a decision whether the child qualifies to live in here or not. So when a child is in this situation, what I would like to say is all hopes are not lost. The best thing is seek a legal advice for us to discuss your circumstances and let us know the way forward. Because when you look at it, the parents too might think that, oh, okay, I've heard the law says at least when the child is 10 years, if the child is born here and that kind of thing. But your situation is the child wasn't born in UK here. And how can you make an application if the child is under 18 and the child has spent 7 years continuous in UK here in order to get a leave? In order for even the parent to also get the leave as well. So what the law or what case law has shown us is that if a child been to UK and spent 7 years continuous here, and the child is less than 18, it will be unreasonable for Home Office to say the child to go back to his parents' country. So as such, what we look at it is we make sure that these laws are confined in the immigration rules in such a way that it will suit the child who is going to make the application in order to get a leave to remain in this country. And the parents as such, if it's a lone parent, being the sole parental responsibility to the child, the parent can also use that same scenario to back and apply to get a leave in this country. On the other hand, if the parents are some sort of joint parents or two parents, they also can go ahead and do apply, but where in this case, the Home Office will look at it on the basis that this application doesn't fall within the rules or outside the rules. Depending on the circumstances, that would determine whether the application falls outside the rules or within the rules. So, MANYE team, when you look at what I've put across, if a child is in that scenario or in that situation, what I can say is he or she has to seek a legal advice, provided he or she can say, I've lived in UK for 7 years, I am under 18, and it will be unreasonable when I put in application to turn my application down and say I should go back to my parents' native country. So as such, there is a hope when such person in this situation to put in an application for leave to remain under the private life rule, being paragraph 276 ADE. So in summary, what I can say is such situation empowers the child to get a leave and build it up on the 10-year route, being the private life, in order to get settlement in UK here.